Okay, everybody pledge allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
George.
Well, you're not supposed to change that one.
Oh, yeah, absolutely.
Okay. Roll call, please.
Councilmember Yaffe?
Here.
Councilmember Tricoche?
Here.
Councilmember Salver?
Here.
Councilmember Reed?
Here.
Councilmember Leonard?
Here.
Councilmember Fuller?
Here.
Mayor Brewer?
Here.
All present.
Okay. So we're going to do public hearing number 2 first. There was no objections from, so we're going to start with public hearing number 2.
Okay.
Okay?
Public hearing number 2, or item number 3 on your agenda. Hearing for a purpose of hearing any public comment with respect to an application for variance from sections 23-1215B, 23-1215E, 23-1215G, and 15-9.2B in order to renovate and expand an existing home located at 10,000 West Broadview Drive.
Okay. Who is representing the homeowner? Please come forward.
Sure. If I can just give a little background on this. You may recall, and certain council members certainly know, that this house was built and the contractor didn't build it according to the site plan approval when it came.
Frank, can you just,
Sure.
the picture that we're looking at is, I think, item number 1.
It's it's the incorrect one, so we need to move that to number 2.
We don't have anything for number.
Oh, we don't have it on the, okay. You do that.
Right, sorry. So this is not the picture of the home. The home is owned by Mr. and Mrs. Seiden. Their contractor built it out of specification for what was brought before the Planning and Zoning Board and approved. And particularly, it looked like a concrete canyon. So we had a meeting with both the town manager, the town planner, Mr. and Mrs. Seiden, and their council. And we talked about, what was done, why it was done. This was before our town planner would monitor. So these days, anytime anything is built, Michael Miller's office will review it, make sure that it follows the plans, make sure that everything is built according to the site plan approval, and so that what is built is pursuant to the plans. This contractor did not do that, and at this juncture in time, Michael Miller's office wasn't doing that then. So we had a long meeting with the owners of the home and their council, and the town manager discussed what revisions were necessary, specifically adding a lot of landscaping to soften the concrete that was there. The property owner has a medical condition, and he is his condition is getting worse, and he's going to be wheelchair bound. And so what they asked for was to have more concrete than would be necessary normally, so that he was able to move around his property, specifically on the sides, so that he can get from his driveway to his pool and around his property. So the thought was that would be something that the town council could view, the town council could consider, given his medical needs, and this could be something that could be approved subject to your thoughts, but only for the period of time that they own the house. This could be one of those variances for the concrete in the house on the ground that could be approved as long as they own the house. One of the conditions that run with the land, at which time, upon a sale, they would have to bring that into compliance in order to clear the title. The other item on the house is the contractor built the roof a little bit too wide. and it encroaches upon the setbacks. I understand that they have letters from their neighbors saying this does not bother or affect them in any way or shape or form. If the variance weren't approved by the town council, they'd be required to rip off their entire roof, put on a new roof at a huge expense in order to shave down a couple of feet. So they're really two separate and distinct items before you. One is the concrete for his ADA purposes, and the other is the roof.
I have a couple questions.
Before we start the hearing, all those who are going to testify in this variance hearing, raise your right hand, please. Do you swear to tell the whole truth, nothing but the truth, so help you God? Okay, thanks.
Sure.
First of all, who is the contractor?
I will let them talk about that, but
Just the name?
you certainly know who the contractor is, and you've had a couple of issues in the past.
And I will say that this is a supermajority to approve the variance, 5 out of 7, just to remind you.
Okay, and what you're saying is that as long as they live there, the house can stay, and if, when they were to sell, then they would have to bring it into compliance?
But not
With
the roof.
regard to
But
the
not the
concrete,
roof, right,
yes.
But what I'm saying,
The roof is the roof.
The roof.
You either approve it or you don't approve it, but obviously that wouldn't be changed at any point in time. It's more the concrete. But when we had a meeting, well, we've had several meetings, several conversations with them, and really the condition that Ron had articulated was he wanted to soften the landscape. He wanted to soften this abundance of concrete, and they complied in all respects. They added a lot of hedging, they added a lot of vegetation, they did everything that Ron had asked for to soften it while still providing, potentially, subject to your discretion, this extra concrete to allow it.
did we have building officials go out there while they were building it to see if the...
We did not. That was not while...
Frank, if
while
I
it was-
just could clarify, there's two things. There's, as Frank mentioned before, at this time, when a building or a multifamily or single-family house is built, there's 3 visits from Mike Miller. There's the building code, and then there's the zoning. So for zoning, Mike goes out 3 times. Make sure when the house starts to be built, it's in the setbacks, about the middle construction, to make sure that the plan is generally being followed, windows, doors, roof eaves and things of that. And then, of course, the final inspection, which is when, in the old days, that's when they would go out and then they quote all these things. The building department goes out and looks at the plans and makes sure that the building is built to the Florida Building Code, which is not necessarily the same as the zoning code. So the house is built, according to the building code, so it's a sturdy and well-built house, but it's just not according to it doesn't comply with our zoning. So that's the big difference, which we've ended, because if we had a problem also on the multifamily side with a fire department requirement to put stairs out in the setback. We no longer allow that. We come along and we do these periodic inspections to make sure nothing's going that we don't get caught at the end with a surprise of a stair or something that's not in
And
compliance.
so we're doing that also...
We do that now,
on all
both
homes,
sides.
so that this situation would not happen, because
No.
we would have caught it, the town would have caught it, because they're novices, and
Right.
so... okay.
Right. This home does not have a certificate of occupancy. We have not issued that. The building department has not issued that because of these matters. We had asked the property owner to do various items, which they did, which was the landscaping and the like. And once that was done, we then allowed them to come before you for these variances.
Thank
We
you,
didn't
Bob.
allow that prior.
I had read Michael Miller's report earlier. I mean, I did note the addition of a significant amount of landscaping, as you indicated, but Michael Miller's report talks about inadequacy of certain trees and so forth, but that's not part of this evening's subject. I mean, if there are tree issues, that has nothing to do with variance request.
That's correct. That is. I can tell you that I think, Michael Miller was involved with all of the initial discussions, and I think I think as items progressed, it was more between the town manager and the attorneys, more so working through some of these issues. So I think some of the report kind of reflected the fact that, there were other discussions and other items discussed that didn't necessarily loop Michael Miller into.
I got a couple things. First of all, why is this taking 3 years? I mean, that's the first thing right off the bat. I mean, this seems to be something that should have been addressed, whether before us or in some other manner, years ago.
Yeah, there was a little slowdown and breakdown. My understanding, and the applicant can talk about it, a lot of it was the medical condition of the property owner and some other items that occurred. There were a lot of discussions that we had and requirements that we had, and quite honestly, we did not allow this. They had filed this application a while ago. We didn't allow them to come forward to you until all the conditions that the town manager had articulated were done. So they actually put their request in a long time ago. It actually expired, and we had them resubmit it. So that was
So it
part of
started
the
a while
factor.
back. The other thing I wanted to ask you is there, I mean, to your knowledge with that, I know you wanted to let the applicant talk about the scenario with the contractor, but is there right now any ongoing litigation between the applicant and the contractor?
Not to my knowledge. I don't think it's ripe. I think if you were to not deny everything tonight, and the contractor built something that couldn't get a certificate of occupancy, I believe they would have a very ripe case.
That's why I'm going down that road, to find out what the story was, because I also don't want to get us in the middle of something if there is, ongoing litigation, but thank you.
Okay, this way. I see. Or Kelly or Elizabeth.
I'll wait till after they speak.
Okay. Would you prefer that they speak?
Yeah.
If you can come forward, please. State your name and address for the record, please.
Sure. Good evening, Mayor, council members. Ethan Wasserman with Greenberg Traurig, 333 Southeast 2nd Avenue, here on behalf of the property owner. We are here tonight requesting a few after-the-fact variances. I think your town attorney did an excellent job introducing the item, so I'll try to keep my remarks as brief as possible. The variances can be broken up into 3 or 4 categories, but before getting into that, I just want to make a couple background statements to kind of explain where we are and what has transpired to a degree. My client, who is here tonight, has significant health issues. And for privacy reasons, we don't need to discuss the specifics of those health issues, but I can share that it's a deteriorating condition, and mobility and handicap accessibility is a major concern and focus of ours when designing this home. Second, hindsight is 20/20, and my client purchased the property in 2006, and at that time, there was a home there that was constructed in 1956. My client hired a contractor, Mr. Shear, to perform the renovations on the home, and it was our client's understanding that he had a strong track record of success in the city and a strong reputation. We realize now that that was clearly a mistake, and a lot of the problems that we are facing here today are derivative of that issue. So, fast forward a little bit, in 2013, my client came before the Planning, Zoning, and Appeals Board, had a design approval, went through the appropriate channels to get a full building permit to renovate the home, and construction commenced. As part of that process, as is routine when you're under construction on a home, plans changed, tweaks were made throughout the property to respond to the evolving and foreseeable needs, health-related needs of my client. We fully understand and appreciate that when plans do not match the zoning code, you need to apply for a variance or modify your plans. That was not done, and that is why we are here tonight requesting after-the-fact variances. So turning to the variances, first and foremost is the roof. The roof has 1-foot overhangs on the north side, on the south side, and on the waterfront side of the property. Now, shop drawings were submitted to the city, but they were not routed for a variance. That was improper. We understand that. That should have been looked at when they were doing the roof and either applied for a variance or, again, revise the shop drawings. I would emphasize that Three people directly affected by this variance, because this is at the top of the structure, are our neighbor to the north, our neighbor to the south, and our neighbor to the east. All of them have expressed support. We have 2 letters of support from the south neighbor and the neighbor across the street. We'll submit those into the record after my presentation. And we have a verbal support from the neighbor to the north. I believe they called in to the town clerk to express their support. They weren't able to sign and scan in before the hearing tonight. The second, I'll call them collective set of variances, relate to the walkways and the pool deck. These are basically, if you're in a wheelchair and you're on the side of the property, you have 10 feet from your structure to your side property line. Add in a couple feet for your spacing, for your mechanical equipment, your AC equipment, your walkway, and then your green space. We need to have a continuous path to be able to walk down the side of the home, to access the mechanical, to access the AC, just like any one of us would want on our own property. The pool deck is 6 inches higher than allowed under your code. That is a de minimis amount for the entire world, but for a slope purposes, for ramping purposes, if you're coming in the home and going to your pool deck, inches matter in terms of feet, in terms of the slope, the degree of your ramp to get down to your pool deck. So right now, there is no ramp. We anticipate and we envision that we will need a ramp, and this will help us prevent having a ramp basically looping down to your pool deck. And then the last variance is in the front of the structure. It's on the street side, and again, it's just an access issue into the property. So I will, in closing, say that if we could go back in time, we would do things differently. We acknowledge that. My client realized he entered into a business transaction with someone that didn't do right by him and didn't do right by the city, and we apologize for that. So I'll close my presentation. We're here to answer any questions you may have. To the extent there's public comments, I would like to reserve some time for rebuttal.
Thank you. Isaac? Any questions?
Yeah, I do have a couple of questions. What prevents, other developers coming in here and basically violating the code? We don't pick it up right away and then ask for after the fact permission to do what they did. What is that? Where does that leave us as a council regarding governing the properties that are within our...
Sure. One, the process is very different now, where we have continuous inspection. Two, there have been instances in which folks who have built properties or constructed properties that haven't been pursuant to code, we've made them make changes. I can think of several that we've done, and I've also can think of a few that we've allowed as well and given after the facts as well, and also, multifamilies, single-family homes as well. I think every case stands upon the particular facts. I know that there were some building that was done as his condition changed, and I'm not saying it was correct or not, but that was some of the things that this contractor did for them. It's up to you, though. Everything's different. I can tell you other people who are very sophisticated who have kind of disregarded the process. We've made those folks bring things up to code. I can think of a few right off the top of my head.
Now,
I will just add one more thing, which the council is well aware. What you do here on this matter does not create any precedent for any future application or fact situations that may arise. That's just a matter of law.
I get that, Craig, and in a technical sense, I'm sure you're correct, but in a practical sense, other rulings that we've made have often been thrown in our face, either in the public arena or privately. And this is something that is very, very serious that we've been dealing with for many, many years on the council. There are plans that are submitted, and then the end product does not reflect what the plans and the drawings that were submitted is, and it's a little bit, frustrating. Is there any way that we as a council could put, like monetary sanctions on this property? Because I'd hate to sit here and just say, yes, okay, and I feel very bad for the Seidens. They're, you know, our neighbors, you know, we see them all the time. But, I mean, this is, you know, this is, we're here to control this
Yeah, we do.
type of thing.
Sure.
And, you know, if there was a way that we can approve this particular case, but, you know, while putting sanctions on them, and I mean significant sanctions, I mean like making them buy TDRs, sanction type of things, you know, where, you know, let's say, you know, this violation is worth 1 TDR and this violation is worth 2 TDRs, and say, hey, look, you know, we'll grant you your CEO for your multi-million-dollar property, but, you know, you need to buy TDRs to get a permanent certificate of occupancy for this house.
Well, let me tell you what the code allows, and let me tell you the last time that their counsel was here before us. So there's a separate code enforcement matter that involves this property. As of today's date, the outstanding violation for them living in this house without a certificate of occupancy, and for some of the other issues to date, are more than 6 figures. This matter has been before Mr. Krupp, our special master, and counsel has appeared before him. We cannot issue a fine until this is resolved and the case is final, but right now they are looking at a 6-figure code enforcement fine. And this will make its way back possibly to you as a counsel or to the litigation committee. But that's where that fine is presently. So this question is not without an impact that's before the code enforcement presently.
May I ask a question? What we determine here tonight, does that impact any of those proceedings?
We cannot finish the code enforcement until really it's done, because as of today's date, there is no compliance, and therefore, without compliance, we can't issue a final fine.
But does issuance of a variance of any kind preclude them from any of the fines or findings that we may have in the future related to that matter?
No.
Okay, thank you.
That's going to be a separate issue before Mr. Krupp, who's here tonight.
Public comment after this?
Hey, one other quick-
Wait, 1 second.
What? Sorry, no, did you have something?
Go ahead.
Just one other quick question, because, you know, Frank was speaking a few minutes ago about potentially allowing this, granting the variance, but under the condition, under title, that it would actually have to be retrofitted afterwards if there's ever a sale of the property. But I'm wondering how feasible that is, because you're talking about, for example, the pool deck as the example you used. I mean, obviously the roof is a different story. That we know can't be done unless later on somebody converts it to a flat roof. But the pool deck, I mean, you're talking about potentially significant destruction of the property. So what are you advocating along those lines?
Well, I think the proffer by the city attorney was for the at-grade related improvements, the concrete.
So that's the only thing. You know, I just
Yeah.
want to be clear. So the only thing you're talking about is the concrete around the side, not. So the roof is not the only thing. It'll be the roof and the pool deck as well that will
Correct.
survive regardless.
Everything else would have to be corrected.
That's what I wanted to be sure.
Correct.
If you were to approve it, yes.
Yeah, I'd just like to say, first of all, I'm very sorry for your struggles, Mr. Seiden. And you look very strong and fit. So, I completely understand the personal hardship here, but I had the very same question that Isaac asked about preventing this. And, you know, we have seen other egregious violations of the setback, or stairwells recently were put in, 5 feet into a 10-foot setback. And we've also seen in recent hearings where some structures kind of appeared out of nowhere. You know, I realize this is documented, and in regards to the retrofitting, you know, a little easier to track than some more mysterious ones. In principle, I have a very hard time doing this because at the special master hearings, it's typical that we see these fines reduced to, anywhere 10 cents on the dollar. And I'm not sure if even having an egregious fine would prevent it, because then I think, there could be a mindset of, well, what's the average fine? Yeah, we'll just buy it out. So this is a very difficult decision, and if there's, some more testimony, I'm looking forward to listening to that. But
I would just add one or two more things in response. In terms of the monetary factors, significant cost and expense has gone into trying to bring this into compliance, to trying to come to terms with the city. It's not, I don't want to speak so callous, it's not a free pass, the variances that are being given here. There was a wrong that was done, and we've been working for the past 2 years to try and make this into the best situation that we can. So we have been actively working between architects, lawyers' fees, consultant fees. A lot of time and money has gone into trying to make this as best as we can. I would also add, in terms of the setbacks, there are no vertical, it's not a vertical structure that's in the setback, it's the at-grade pavement in this case. So I understand the concern of a developer that wants to build a home and put a 5-foot setback where 10 feet is required. That's something that every city would want to avoid. In this case, we're talking about the pavement. We're talking about the walkway for accessibility. It's not the vertical, the 2-story plane that goes with the home. So I think that is a mitigating circumstance difference from some of the other things you may be concerned about on future developments.
Can I clarify something? Mr. Seiden, I didn't mean to imply by saying that you look fit, that, you truly are not in need of, future accommodations. I just was a compliment, actually.
So note, Frank, Craig, there's 6 variance requests here, and each of them have to be treated individually in essence. Some could be approved and some could be denied, is that correct?
That is correct.
Yeah,
Go ahead.
no.
Well, there's a couple things. One is, you get a builder, right? The builder comes out, you trust your builder that's going to build according to whatever plans you have. We have changed the way we do things, specifically because we find that they don't build accordingly to what we think they're going to build. We see it over and over again, and so I think that some of it, my understanding from you and what you're saying is they trusted the builder to build according to what the specifications were that the town agreed. And then they found out after the fact, right, that they did not build it correctly.
It doesn't comply with code, correct.
That's an issue between them and the builder.
I understand that, but now we're in a position, unfortunately, where also we, the town, did not go out there over a period of time to see and to check, because this is not the first time that we see plans and we see, places like Kelly says, and then all of a sudden, the plans don't match what either P&Z has said or what is supposed to be there, and then, we also need to get a better handle on what we're doing and how the plans actually create. As far as, the ADA, it's after the fact, the milk is spilled, but the gentleman needs assistance. And I, for one, am not going to vote against somebody who needs wheelchair access. I'm just voting for I will not. The fines are separate. That he has to take up with the special master, but we need to do a better job on our end also. And if a man comes before us who unfortunately needs assistance and needs ADA requirement, I, for one, will not vote against that.
Nope.
Stephanie.
For myself.
I just wanted to note, I've had a number of conversations with Ron and with Frank about this particular house over the years. Just the fact that it was not in compliance and the Seidens are living there without a certificate of occupancy. But my understanding also is that, as Ron had indicated, the town and Frank have indicated that the town has changed its procedures as a result of this particular instance, so that it will not happen again, or at least to this extent. There's more monitoring and more review.
There's hundreds of permits that are issued, probably over 1,000 permits. The ones that we talk about, the stairwells, that came as a result of the fire department. When a lot of the multifamilies would go down, a health safety requirement would change, and then a stairwell would be added. And at that time, it was acceptable to put a change for a stairwell for life safety into the setback. Because it really was a big, we didn't want to see that. Then it comes back to P&Z. We said, no, change your parking, do something different. And they had to figure out a way to push the stairs or whatever the modification was. As a result of that, I didn't feel that I wanted to go through trying to explain it's the fire department or some other agency that forces these issues. So that's why Mike Miller's office now And I know, we're talking about this like this happened yesterday. This is a long time ago when you really think about when the whole project started and everything goes on. It's years ago. So that's when we start to really monitor single-family homes, as well as, we started with just multifamily, then we did single-family, because these things do happen.
Jordan?
Yeah, thanks. This is a very difficult situation. Obviously, we don't approve a lot of variances. I was aware, as Ron mentioned, about, the many different discussions and times this has come up. In fact, this has actually come before our council before. This isn't the first time we've dealt with this house before this body. Just for the record, my understanding that when it goes to special master, the special master only has the ability to reduce the fines up to 50%. So that's just for the record. It's not pennies on the dollar. It's really 50% is the most, and then it could potentially go to the litigation committee. But dealing with this, I have to tell you, the town has some responsibility, not just to protect the town's interests, but also to protect the property owners, the residents. The Seidens are residents. Before they moved into this home, they lived here. They were residents before. This is their third home that they've lived here. And they've lived twice once on 97th Street and once on Broadview Terrace. We're supposed to protect their interests. And I understand completely what Josh was mentioning as far as the issue between the possible litigation between the residents and the contractor, who also happens to be a resident. But I have to take into account the fact that they're not the contractors, unless if they specifically told the contractor, do this, and the contractor went against his license and did something. You have to understand that where's their fault and where's their suffering as far as what they've had to deal with. Obviously, without any exception, there's significant fines that they could potentially pay just for the sake of living in their home without the permission. I am not of the greatest opinion of granting variances, but I have to say this is one of the ones where you have to look at the totality of the situation, not just Mr. Seiden's health, but also what's actually was done wrong. If all of the parties that live in the immediate area don't have an issue with the roof, and the roof is the most major issue, that says something. As far as Mr. Seiden's health and being able to access his property, that certainly is something worth noting also. By the way, it was mentioned, I think, by Frank, that we've had instances where we've granted a variance, and then when the applicant moves or passes on or something, that we change it. That happened on 9800 East West Bay Harbor Drive. We did the same thing where we allowed someone to park their car in tandem parking and said, well, when you sold or passed away, we would change it. So, we've done this before. We've worked with the applicants. I'm of the opinion of granting the variances because, like I said, it seems like to me, when it comes to the Seidens, they've spent a significant amount of money purchasing the property and building the property. It doesn't seem, in my opinion, in my humble opinion, that they were doing this in order to get something more. In retrospect, it doesn't seem to me to be a money issue. It seems to be where they want to live in the community and be good neighbors. And this is an unfortunate situation that obviously everyone wishes never occurred, but at some point, money can't fix this. So we have to step in and kind of say, you know what, this is it, and we're done. So I'm gonna be voting in favor of the variances.
1 second,
I would like to see the letters from the neighbors. Did you say that you brought them?
Sure.
Okay, well, that's happening. Josh?
Yeah. Yeah, they're coming up. I mean, look, I'm not going to disagree with everybody with regard to the concept of, obviously, Mr. Seiden, it requires certain adjustments to the home. I don't have a problem with that. I do disagree with two of my colleagues with regard to that, saying that the town, missed on its opportunity. The fact of the matter is, it's not a requirement for the town to do that. It's not a requirement for the town to go out and make the additional inspections to make sure everything's being built. That's at the end. This is something that we're now doing because we realize it's a better method for doing it. But I don't think the town failed. I think your contractor failed. And I think that's where the blame needs to lie, not on the town. And I know you guys may disagree with that, but the fact remains that, what the code said was known. The town's not supposed to be out there every day looking and seeing every little part and measuring everything up and down. That being said, quite honestly, one thing that Kelly just asked for is going to be the key issue for me as far as the letters from the neighbors, because they're the ones most affected by this in this instance. The only other thing I would ask is, and I'm assuming the answer is no, but I want to be sure, if we can get any confirmation, I don't see Mr. Miller here or anything like that, but just making sure that the raised deck is not going to create a drainage issue later on for neighbors as well. That's the only other thing.
I can't answer that specifically, but Chris, we do have a representative from Mike Knowles' office.
The drainage would be up to the building official.
Okay.
Thank you, Matt.
Can you come up? You need to
Please come up.
Come up and introduce yourself.
Because that's one of the reasons why that is at the height.
His answer was the building of Dale would...
Sorry, Chris Gratz for Michael Miller Planning Associates. The drainage of the property, that situation is handled by the building official with the runoff, so I can't speak to that.
Well, I'd want an answer on that, just to make sure, because before we allow variance, I don't want to have anything come back later on that the neighbors may be fine, but then we have any kind of issue flooding. And so is there anybody we can get?
Have we had any complaints? I mean, this deck's been there for about, 2 or 3 years, and have we had any complaints that you're aware of on it?
No, I mean, not that I'm aware of.
Hurricanes, too.
And specifically, the two neighbors that would be affected by that are both in support of the item. So I would assume if they had drainage issues or buildup on their property, they may be unlikely to sign a support letter.
Oh, Josh, if I could point out.
Yeah, please.
I think when the deck was replaced, originally there was, the concrete replaced, I think, brick. The idea was when the new plans were in, it should have been not built out. They built basically what was there, instead of stopping short of the fence.
As long as the height, because we were talking about a height difference for ramp, I just want to make sure, because, neighbors may come back and say, it's great, no problem. I just don't want to have a scenario where they come back screaming at us if, flooding comes up or anything else later on, where they say, well, why is this deck higher and it's flooding into my property? So that's one of the reasons we have code. I mean, obviously, we're doing this to make sure everybody's protected, make sure everybody's property doesn't interfere with the rights of neighbors. If yours doesn't interfere with the rights of neighbors, I have no problem with this. I just want to make sure, and I want to hear from a building inspector, that's one thing I would like to have, is just an answer that this is not going to create a flooding issue. Because the roof, I understand the argument. The concrete on the side, I understand the argument. I don't even have a problem with the deck, as long as, like I said, it's not going to create a future problem that the neighbors don't know now. That's the only thing that I want to hear.
I just wanted to make another comment. I agree with Josh's comments regarding responsibility. We hire contractors, and we believe that or would hope that if they're licensed, that they understand the building code and they understand the responsibilities as licensed contractors. Our building department gives out a great deal of information to homeowners and contractors as to their responsibilities when they're building anything in this town. I have some concerns about, I just think that the town needs to look at this particular contractor if there are other issues such as this. And I'm not going to get into legal issues of, contractors who can or cannot work in this community, but I have some concerns about that particular contractor. And I'm not going to put that on the property owner because, they rely on the expertise of their contractor. And I would think that the contractor, because we've talked about this for years, that plans, projects, whether it's a single-family home or a multifamily residential property or an office building, have to be built in accordance with the plans or the approval given by the Planning and Zoning Board. And if there's anything at all, other than a minor little tweak, basically, that is different than was approved by Planning and Zoning, they've got to come back. And I'm fairly certain that this contractor knew that, or should have known that.
Just out of curiosity, what...
Elizabeth wants to go.
Oh, okay, sorry.
I have a question and then I want to say something. The question is, you said that the Sidons have done upgrades on their driveway, which we can see. Is it in compliance with the code as was written when they originally built? Because I know we just updated it. So currently now it's still not within the code.
That's correct.
But is that because they need the variance for the ADA?
Yes, that's why they're asking for a
But that's the only reason?
With regard to the driveway, yes.
With regard to the driveway, okay. So the first thing that I want to say is, thank you for coming out and meeting with us. I always appreciate when the owners come out directly and have conversations with us. This is a very difficult issue for all the reasons that my counterparts here have talked about. And I do, want to say first and foremost, I am extremely sensitive to your needs and to the fact that this is your home, and that is, for me, one of the overriding issues here. And I know a lot of my fellow counterparts here have dealt with contractors before, and you put your faith in what they're doing. I think that there's a couple of things that sit on my heart. The first one is the precedent. I know that we say that we're not setting a precedent, but I agree with what Isaac is saying, that we all know that once something happens, it's on people's minds and they remember it and they bring it up. So whether or not it has any legal ramifications or not, it certainly has ramifications in other ways. I do appreciate everything that you guys have done for the driveway, and I think that that's a great show of faith that you've made. And I like the idea of providing a variance only during ownership. I will say that I am in favor of giving a variance related to the ADA requirements because that allows you to live in your home. For me personally, I think the issue of the roof and things like that is between the contractor, unfortunately, and you, and it's something that it sounds like the contractor is culpable for. But when it comes to the ADA requirements so that you can live in your home, for me, that is one of the overriding issues here.
Can I just ask one more
Yes.
thing, real quick? This particular, from Prosper Mullen, who's actually the applicant's letter, that lets you go first, this letter on there, do you know who's drafted the actual letter? It just seems a little suspicious to me when it says in there, insert neighbor name, insert neighbor address.
It's a fair question. When we represent clients, we always draft letters of support because the neighbors don't always like to take the time and write out a full-blown letter themselves.
Right.
So we're
So-
asked occasionally to.
Right, no, I understand that, but my point is, I just wanted to be clear that this was not a simple letter that came from the neighbor. This was something that your office drafted for them to sign.
After meeting and discussing with them, sure.
And was intended to, just because it's a little bit of an insult to us because it's the fact of the matter is it's drafted in a manner to make it look like it's a layman writing these things with the grammar off and everything else and apostrophe. So I find that just personally a little insulting. If there's a standard
apologize you feel
affidavit
that way,
you want to sign, have them sign. That's fine, but acknowledge the fact that you drafted it, not that the neighbor drafted it on their own for the goodwill of the matter. It just doesn't come across well.
I was going to ask, what should have, instead of 6 inches, what would have been allowed? What should
On the pool deck?
Yeah.
It would have been 8 feet NGVD, so 6 inches less.
Okay.
Do we have
Or,
any...
excuse me,
I'm sorry.
7.5.
No, 7.5 feet?
Yes.
Okay, so.
I think Craig wants
I just want to make this observation to the council. Since the law is that a variance, if it is granted, can be granted in whole or in part or with conditions, the council might consider a condition that if any or all the variances are granted, that they be conditioned, among other things, on the satisfactory resolution to the town of the special master proceedings, because I really don't want to buy more litigation and have to record a fine against the residents, which, because it's homestead, can't be foreclosed upon, as we know from prior experience with the Fongs. And so that is an outstanding condition that could be crafted into an ordinance, into a variance, along with a covenant running with the land, that the certain variances would be corrected and canceled and null and void upon the cessation of the ownership of the property. We would craft that, but I'm just thinking out loud, would the council consider that? Josh, I'm sorry.
Could we make a condition of approval that they stop all special master hearings, and just sign some type of agreement where stipulation that they do not go to the special master, they waive their right to appeal to the council for the fines, and just pay the fines and after they pay the fines, that we can grant them their,
The
you know,
variance-
give them-
well, the variance-
officially grant them their variances.
The variance would be granted subject to certain conditions precedent. They have counsel here, but I'd like to have a resolution of that because it's not our fault that all these violations have occurred and that they've been living in there, and we're spending time and money, and we have fines, and they need to be addressed. And I don't know what council's position would be, but it would seem to be an equitable a resolution and a partial quid pro quo, not the whole
And
thing.
before you answer that, one thing, because I don't have a problem potentially with that, but I also would want, going back to my point, because we don't have a building inspector here, I would want one of the conditions here being for approval at least of the deck by itself, that the building inspector signs off on the fact that it's not an additional flood hazard. I just don't want, like I said, that's my big thing there. I just don't want to find out later on and have the neighbors come back angry at us that we
Understood.
allowed something that's a flood over to them.
Give me 1 second, bear with me 1 second.
How much is the fine? I mean, we're talking about...
6 figures is
Okay,
Well,
but
I mean,
But it's over 100, but like how much?
how much is the fine?
I can tell you that it was approximately 100,000. It's still running from day to day.
It's still tolling,
Yes.
even though that they applied for the variance.
Well, because they don't
Because of
have,
the CO is
they
not-
don't have a CO.
Right. That's
So they've
nothing to
been
do-
living in the property without a CO for the past
Yeah, we
couple
still
of
provide
years.
water.
Just to that point, though, I don't want to get technical. The property, I don't believe, ever lost its CO. To be precise, the original home was constructed in 1956. In order to lose your CO, the city has to revoke it. I don't think the city revoked the CO, but to your point, we're happy to agree to a condition on the drainage, on the percolation for the deck, that we will work with the city and make sure that there are no drainage issues onto the neighboring property. We fully support that.
Then you've made me happy, that's all.
Can we clarify on the CO? Because that wasn't what we were initially advised.
Okay, now, let's move on to another condition.
No, but I'd like that
Yeah,
question
I'd like to
answered.
know.
It's our
is that-
position that there hasn't been no certificate of occupancy approved for this project as it's been redone.
It's a new building.
Right.
That's nonsense. There is no CO, and
Okay.
I'd stake my reputation on that. There is none.
Thank you, I just wanted to make sure because I heard
Right,
everything.
because that's a critical difference.
Isaac, you're up.
Yeah,
And then in terms of the fine, we will process that with the special master. We can't agree to the fines tonight. We don't know what the amount is. We would just be waiving our rights blindly. We're not in compliance yet until the variances are granted, so we would respectfully ask that that be processed under the law, under your city code, through the special master.
That's a problem.
Yeah, that,
You see?
you lost me on that one.
It's a problem, because you need 5
So,
votes.
if you guys need to huddle or something like that.
And if this is
I'm a no
voted,
vote right now.
and if this is voted down, you can't come back.
Exactly.
Why don't we do this? Why don't you have a conversation?
I appreciate that,
break
thank
for
you.
5?
And let's break for 5 minutes while you have this conversation.
Actually, we can...
Well, why don't you
Or do you want,
Let's go back to-
let's,
why don't we
we'll
go
go
back-
back to number 1.
Mayor, we could go on to the next one.
We'll go-
That's
we'll
what I'm
on
talking
to the
about.
next
We missed
one.
number 3.
And we will come back.
I appreciate it, thank you.
Have and when you're ready, you'll let us know. Okay, number 1.
Public hearing number 1, public hearing for the purpose of hearing any public comment with respect to an appeal filed by Pronam X LLC, Mr. Prosper Maman, regarding September 4th, 2018 Planning and Zoning Board decision to deny the site plan submitted to construct a new two-story single-family residence located at 9955 West Broadview Drive.
Before we start, Mayor, I need to swear in all persons who are going to testify, including anyone in the audience. Raise your right hand, and you swear to tell the truth, the whole truth, and nothing but the truth, so help you God. All right, this is also a quasi-judicial proceeding, only requires a majority. Frank will give you a little bit of a background from being present at the Planning and Zoning Board. This is an appeal. The applicant will have a rebuttal after there's after the initial presentation and any other comments. The applicant will have the final statements. I will say that this is a de novo hearing. That means that it's like it never happened before Planning and Zoning, and it starts all over with any evidence the applicant wants to present. The council has the record of what went on in the before planning and zoning, and if it's okay with Rick, I'd just let Frank summarize what happened, and then you could take over.
Craig?
Yeah.
I don't believe that we have any record from what went on at planning and zoning. We don't have minutes of the meeting. And I understand it's de novo, but, I mean, Marlene had pointed out that, you know, planning and zoning board is required, I'm reading from her, is required to give a reason for denial.
Right.
And frankly, the reason is very, it's like...
The reason is what was given.
Well, it's a couple of sentences. I mean,
Yeah,
we
that's
don't all
what-
attend the planning and zoning boards,
Right.
and meetings, and I understand that in the appellate process, as you say, de novo, we need to consider this project, but I think generally it's helpful to have an understanding of what the planning and zoning board members, why the planning and zoning board rejected this project twice, and obviously they can't speak on this evening, but I think in the future that we need a more detailed report and explanation from planning and zoning board when they reject the project, so that we have a more meaningful appellate process.
I agree, and like I say, Frank will give the background that he can. Mike Miller was there, he's not here now, and that's all we have, and the statement of reasons. Frank, go ahead.
This project came before planning and zoning twice before. And when the town council used to be planning and zoning and then divested that right, hold on one second, I'm sorry. Divested that right to planning and zoning, we enacted the ordinance that we did. And so for many hearings before the Planning and Zoning Board, you know, I discuss what the ordinance is. It's like an art and science. Every project that comes before Planning and Zoning technically meets the code. Otherwise, it wouldn't be brought there. But the art and the science is both objective and subjective. You know, the subjective is that whether it's in conformity with the condition, the Planning and Zoning Board shall examine, approve with conditions, or disapprove whether it's in conformity with good taste, good design, in general, contributes to the image of the town as a place of beauty, spaciousness, harmony, taste. It's not of inferior qualities. It's in conformity with the standards. And the site layout, the harmonious relationship, the building design, the harmony of materials, and how it fits into the overall composition of the town. So that's the art and the science, right? We all know that it meets code, but the issue is whether or not it meets the other subjective criteria. Their view of this was that it was a large, very large massing of a home. They had given very clear directives as to how they thought it could be broken up, and they gave suggestions. Many of those suggestions, if not all of them, were, or many of them were put into the version that you see. The Planning and Zoning Board did not felt, if I'm saying this correctly, that it looked the massing looked too much. It didn't look like it was broken up and articulated in various places, and that the way it fit on the subject property lent itself to look large compared to what the surroundings were for the immediate homes. And so I believe that is the reason why it was denied with a little bit more specificity than what was set forth. I think I've said that correctly, or at least I hope I have.
The surrounding homes, meaning there are no large homes in that area?
Well, I think if you looked at the site plan showed a very small area. If you were to actually take a larger aerial view, some of the largest homes in the town are actually there. They're actually on the water. So if you were to go back a little bit and take a larger scale, and depending upon how you did your viewing, yeah, you would see that some of the biggest homes are all around it, and it's probably, probably falls in line with some of those sizes as well.
So besides the size of the...
Hey, Frank, I'd just like to add one thing. They were also asked to reduce the size of the house a little bit, and I believe they complied with that also.
So they came the first time, they gave them notes. They came the second time, and they followed what what they were asked for.
Well, I think...
Because I have nothing to go by, so I don't know what...
Sure, but what you're looking at today, and how we set up this ordinance was before, the town council was planning and zoning, and if you were to appeal, you'd have to go to the same people. The beauty of what we did in this code is that now you get to look at it as if you're planning and zoning. You get to look at this.
No, I
But frankly, we want the
understand that.
guidance. The whole point of this was that we get the guidance from planning and zoning, that they would give us a little bit more. 2 lines doesn't provide the guidance we're talking about. That's the intent here.
Well,
Other than the no from them, we wanted a little bit more information.
right, but
Did they not like the aesthetics? Did they think it
yeah.
was too big? Did they think what was wrong? Did they think it needed a window on the left versus the right? I mean, that's the point of us evaluating.
Before you answer, just,
How many votes do you...
is this a simple majority, or is it?
Simple majority, yes.
But the thing is, it's very hard for us, because like,
me see.
we rely on planning and zoning to give us guidance of what, you say articulation, well, that could, that's subjective. I don't know what the planning and zoning did not like about it, and
Right.
why after they came the second time, they're here.
Sure.
And why didn't they go back again for the third time? Why did they come
Well, it was
before us?
denied. It was denied. And just for the record, because I know you have it before you, but it's important to read it in. It says the project was denied because the board believed that the building mass as designed, based upon the applied setbacks, height, and articulation of the facades, was not in context with the size, immediate surrounding area, or the neighborhood. In addition, the board believed the design of the house did not properly utilize the specific characteristics of the site lots. Sorry, this is Jerry Gakovic. So,
Frank, before, I just want to say that, I mean, it's a fairly broad statement, and, we have our ordinance establishing the separate planning and zoning board. I mean, one of the reasons we did it was because we wanted to have several, at least 2, 3, 4 architects and other professionals, contractor and so forth, on the planning and zoning board who look at these projects differently than we did when we were the planning and zoning board. So I'm just saying in the future, I understand what that statement is that you read into the record, but I think that there should be more detail in the planning and zoning board's findings.
That's not enough.
Because they're the experts, they're the architects and so forth, and, we will have to make a decision, and we will do so, but I think that the planning and zoning board should provide more guidance in the findings.
yeah, I certainly understand what you're saying. You could actually, if you wanted to, defer on the matter until they give you a more particular reason for their denial. However, I understand why you want to know what they did, but really, this is the town council acting de novo.
Right.
This is a fresh set of eyes,
No,
and you do not have
But
to
could they
rely
have
on
done-
what they did.
Could the applicant, I understand, the applicant wants the house approved as it appears before us this evening, but just for argument's sake, the applicant could have said, well, the applicant could have decided to make additional changes, then go back to planning and zoning.
Correct. But it would be a new application.
Right, a new application.
What was the final vote when they denied?
Oh, gosh.
I think, Ron, you told me it was unanimous, right? There was 6 members present.
So it was
Wow.
unanimous against, okay.
Okay, why don't we hear from
We have
the
public
rep...
comment.
I know, but let me
Yeah,
first hear
sorry.
from the
Madam
representative.
Mayor, Councilman, I'm Richard Krupp, attorney for the applicant. Mr. Maman and his company, Pronan 10 LLC. We find that the...
Patrol of it.
It
there's a handheld
doesn't
as well.
stretch up anywhere.
You can use the handheld one right there.
He's the center, we're just like short, we're shooting guards.
Okay, normally I'm sitting on that side, but tonight I'm here on behalf of the applicant. We find that
Oh, please, sir.
the city's...
There you go.
Hold it close.
Nope.
Nope.
No, it's not on.
Hold it close. It is working.
It's working?
There we go.
Oh, yeah.
It's working. Okay, we find that the Planning and Zoning Board's opinions were arbitrary and capricious. Okay, if you will look at the site plan of the property, you will see that it is in compliance. Mr. Miller has written off on this and approved it. And the floor area ratio is well within compliance of all of the surrounding neighborhood and property owners. Matter of fact, Mr. Maman built a house immediately next door to this, which is even larger. And this lot is an oversized lot. It's over 14,000 square feet. And the floor area ratio here is 58%, as opposed to the lot coverage is only 33 1/3%. The house at 9911, the floor area ratio is 68%, and the lot coverage is 34%. All of the homes that are being built today on the island, because of the cost of the land, are expensive homes. And these expensive homes are big homes. They are designed for large families that are coming here. Mr. Maman's family is going to be moving into the house that he just built. The house that he wants to build on this house next door was for his family. He owns the property immediately behind the house that he just built. They own 5 homes on the island, 6 or 7 condominiums on the island, 3 buildings on the island. He has always built to the best specifications that are possible for the island. All of his projects have never had any problems, have all been in compliance, as this one will be. If you look at the drawings of the property, you'll see it is unique. It's not just a square box that has been approved in the past by the Planning and Zoning Board. It is, like I said, unique. The contractor is here, the architect is here to answer any questions that you might have about it. And we feel that since Mr. Miller has approved everything as it should be, that the planning and zoning, they don't like a window, or they don't like a door, they don't like the way the house sits on the lot. I mean, that's arbitrary. And that really should not be taken into consideration in the approval of the plans that are all in compliance. And he does not set forth in that 3 sentences anything that he specifically does not like.
Well, let me ask you this. I'm sure that you all were at the planning and zoning, and when you had the discussion before they denied you, I'm sure that they went over what it was that they would have liked to have seen differently. We were not there, so we're,
Yes.
but I'm sure that that was your second time going. So obviously there has been some kind of, communication going back and forth between the planning and zoning and the architect or the owners. And so when it was denied the second time, I'm sure there was some discussions of what they thought needed to be changed to be approved.
Let me give you a perfect example of
Okay.
what I was told went on at the meeting. I was not there. I was told that they didn't like the placement of the swimming pool because they thought it would be in the shade. I mean, this is the type of things that they didn't like the fact that one of the walls was a flat wall. It needed some indentation. Okay, I can live with those things. Okay, the pool is the pool. That's the way it fits on the lot in accordance with the plans. So we feel that there is nothing that the planning and zoning came up with that said, this just doesn't work. We don't like this. This is ugly.
Well, before you go down that line, I just want to make sure you're aware, we just gave the Planning and Zoning Board instructions recently for the flat walls, to get rid of flat walls. So
Okay.
I just want you to understand, as you rail against those, you know, you start to lose us a little bit. So
That's a minor issue that easily determines.
I just want you to understand, the audience you're
So then my
speaking
question
to.
is, did you try before, I know that you've come here, but after the second time, whatever the reasonings were, and if they were, were you able, or did you not think that's what they were requiring you and asking you to do, to tweak?
I
so
think
to
the
say?
architect is the best one to
Okay.
answer that question because I was not present
Right.
at the time.
Perhaps he could address that.
Right.
Sure.
Because I'm trying to figure out why didn't you go back for another fight?
And how close was this discussion,
Right,
right?
right.
In fairness to them, the first time there were many suggestions made, and then Michael Miller wrote a report, and they did many of those items. The second time, there was it was denied. So the only option they would have had is one, appeal, or two, come back with a revised version. In fairness to the Planning and Zoning Board, some of the comments with regard to the pool and the wall is more so how the lot is irregular and where they placed the house. And I think with regard to the pool, for fairness to them, it was more of a suggestion and asking them whether they had considered that not as a condition.
But my question is, before they denied it, I'm sure there was discussions of what the reasoning behind, how close were they in coming to some kind of...
Or was it just a matter of
Or
they didn't like the size?
Or they just didn't like the size and it was denied because I don't like the size they could buy? Or was there some articulation, they don't like the you know...
Let me
they
say
want
it.
it far, they want it
So
chunky.
it was not purely size. There's not, I mean, certain members of the board, or a certain member of the board, is not in favor of large homes and has suggested that if, you know, for the various code revisions that we've requested them to view, would prefer smaller homes. However, the majority of the board has not used the criteria of large versus not large. What they've generally looked at is more along the lines of how the massing is broken up, what articulations are there, how can they creatively soften it. And here specifically, they had talked about the front facade and how breaking up some of the massing could be done. And those were the suggestions given. And with those suggestions, it came back the second time with some articulation, with some differences, and they followed a lot of those items.
So then why
but
wasn't it?
they didn't, the council did not, I mean, the Planning and Zoning Board still felt it was not enough articulation, too much massing for this particular lot.
But can I ask a question? In our report from Michael Miller, the one dated August 21st, this was his report
What do they want?
to the Planning and Zoning Board for the second hearing.
Correct.
So this is really important to note because, so this is really important. So in other words, they came before Planning and Zoning. Planning and Zoning made all these comments. They made changes, presented it back. Michael Miller wrote a report that said that, it says it right here, they made all the changes. He recommends approval. It says it meets or exceeds all town land development and landscape code requirements. Applicant submitted plans that were reviewed and commented, and they addressed all the comments. And then Planning and Zoning turned around and denied their application. Is that correct?
That is correct.
Okay.
But
I just want to make sure.
Just so we're all clear that if it didn't meet code, it wouldn't be
No, I
put forward.
understand,
So
but
that
no,
is-
no,
that's a whole different story.
my issue is that they came to Planning and Zoning commented, They made changes, our town planner said they made all the changes, because it says it right here, and then they denied it. So something, you know, it's something in addition.
Right, changes are subjective,
I understand.
and quite honestly, you know, the changes made aren't always the changes intended by the board as well, in fairness to the board, and in fairness to the
No,
property.
but I have to go by what we have, and what I have is the report by Mr. Miller, and by the way, anyone who's read Mr. Miller's reports can tell you that he doesn't really approve really much of anything, so, I mean, this is actually, this has got to be the only time in my life I've ever seen him approve something come before, so that's why I'm shocked, so, you know.
Hear from the architect, please.
Good evening, Council. My name is Abe Brugerdi. I'm principal at American Building Engineers, 1842 East Oakland Park Boulevard, Fort Lauderdale. Thank you for giving me the opportunity to present this project tonight. I wasn't at the previous meetings, but I have watched the meetings very clearly. As we have discussed, this is very unique lot. I think maybe there is not any more lot similar to that in this town, but this lot is about 14,288 square feet. Most of the lot, as far as I know in this town, is about 10,000 square feet. The house and the house next to this project is 10,800 square feet. So it's about 4,000 square feet less. And that building is the square footage on that is 7,500 square feet almost. So we submit the plan to Mr. Mike Miller's office, and you know, as he said, the gentleman was saying, Mr. Miller, he's very tough. I know him for 30-something years, and he has approved the plan. The plan came in front of the board, and the board did not like it. Some of the ideas that we put into this corner property, it was affected by the owner. He wants specifically certain item to be done on this project, like he wanted a big kitchen, big closet, swimming pool to be at the north side, a lot of things like that, the garage to be this way and so forth. So we met all those requirements that the owner wants. But when we present the case to the board, they said the closet is too big. That was one of the comments. The kitchen is too big. We don't like the swimming pool, it's on the north side, put it on the south side. The garage is recessed too far, and this way and that way. So I think from what I see in this town, this project is one of the nicest projects in this town. That's what I feel. I have the picture of all the properties that it is under construction, and they're competing with us at this time based on the square footage, the way the design is, and so forth. One of the specific one, you don't have that on your paperwork, but it just happened that we added to our drawings, is a corner property on 9640 East Broadview Drive. That lot is very similar situation that us, and you will see that there is just a flat wall in the face of the building, no articulation on the south side, nothing on the west side. The swimming pool is on the north side, the same as we have it. But this project got approved. This lot is 10,000 square feet and is 6,200 square feet, 6,250 square feet. And the FAR, floor area ratio on that is 63%. There is no limitation as far as floor area ratio. We can build all the way to the setback of the property, but we have not done that. In the first meeting that we had with the board, they recommend that that we we had some soffits, similar soffit that we have on next door property. They didn't like those soffit. We eliminate all those soffit. A lot of the hand railing, we change it to glass. We create articulation on the east side, south side. We did all of that. We removed the fencing on the east side. We removed a lot of the things. We did everything that we could do. They still don't like it. Why? Why? He doesn't like the swimming pool to be on the north side. I don't know why. The owner is sitting here. He likes the swimming pool to be on the north side. He wants a large closet. What do I do with that? What's wrong with that?
Sir, I don't interrupt you, but we get the point. We get the point that you're trying to build what the owner wants.
Can we see that, please, sir?
Yes. This is the house that I was talking.
No, I understand.
But again, on that,
We are competing with this house.
right, but on that house, we just recently instructed planning and zoning to do something different. So when you talk about you're using other homes, just so you understand, it's no, you're talking about something that was prior to our instruction, so it's a different scenario.
And then we're going to go, I have one question.
Yes.
When you came the last time, again,
Yes.
before planning and zoning,
Yes.
and you made all these changes, what is it that they asked you to do that was so egregious that you decided, what is it that they wanted that you could not do that brought you before to an appeal?
They still don't like the idea to the swimming pool to be on the north side. They want the garage to be put close to the street, and that does not work for our design. This is not the kind of design.
So you're saying that
Yes.
the reason they denied you was because they wanted the pool to be moved, the garage to be...
Correct.
And those were the design defects that they thought needed to be changed?
Yes.
Is that what the
One more
articulate?
important thing is we are covering only 36% of the lot. 36%. And we can go all the way to almost 45-50% of the lot. Also,
But it doesn't give that image. I mean, it's what the percentage, what actually the image is going to feel like more.
correct. And we have more cut and articulation in this building than any building in this island. We have, I don't know how many cuts we have in this building.
Okay.
I cannot put any more cuts on that.
Thank you so much.
Thank
I'm
you.
going to call for public hearing, and then if we have any questions, we'll ask
Thank
you
you
to
very
come back. Thank you so much. Kathleen Kennedy.
Am I talking on 1 and 2? Am I
One and-
talking on
yeah,
this
one and
couple or
two.
this item here?
Both of them.
Both of them.
1 and 2.
No.
It's about the house.
Okay, so let
Okay.
me talk about this.
No, 1 and 2 are the same house. It's on the agenda. It's
Thank
the
you.
same house.
Right.
First of all, hello, council, how are you? You're a smart man, Jordan Leonard.
Thank you.
I'm looking at this couple here. Shame on all of you. Oh, this is all over a fine?
No.
You, excuse me, let me talk.
Kathleen, you cannot talk about that.
Oh, I can't talk about
No,
that.
You gotta
I
talk.
thought somebody said I could talk about 1 and 2.
Look at this house is number 1 and 2 on the agenda. There's 2 parts.
Oh, I misunderstood, I
This house
apologize.
only, please.
Sorry, General. Let me talk about this lovely architect that I just saw back here. If you all haven't gone through Keystone, okay? A home there that a neighbor of my daughter's, Andrea Pacelli, lives in. They have the most gorgeous homes like this being built. He's a witness in Keystone. The architect that we have right now is all the same. It's lousy, it's terrible, it's whatever. Now we have something different. We have something that's absolutely beautiful. It's Mediterranean, it's gorgeous. And to tell somebody about the size of their closet, maybe I have 100,000 clothes, or I have a fur coat or something, and I want sun by my pool. What are we all, dictators here? What's the matter with you guys? Are you kidding me? This is democracy here. We want to build our home for life, and you're going to tell us the size of our closets and where the pool stands or where it doesn't, or the sun doesn't shine? Come on, you're all better than that. Seriously, it's ridiculous. Whoever thought that this planning and zoning has to go? Some are there that don't even know what they're talking about. So you know what? You need to change some of the rules here. And Simone, you need to stand up for the citizens of Bay Harbor, okay? This man wants a closet or whatever. Maybe he has things he wants to put in there. Maybe he can't take the sun. Why don't we all open up our minds and brains and just think of why the sun should be here and the sun should be there? Sunny Isles, a lot of people left Sunny Isles because they took away their sun, the big tall buildings. Now we're doing the same damn thing here. Excuse me, we're doing the same thing here. Come on, guys. You're all more educated than that. State Representative, thank you.
Thank you. Okay. Ken Eskin.
I'm going to talk after.
Talk after
Not
what?
for either one of these things.
Okay.
Sorry.
Okay. Joyce Green. Good evening, if you can please state your name.
Joyce Green, 1360 99th Street. Second time I'm here. I found out about this lovely project because of Nextdoor. And the other house, I have the pleasure of looking at the white wall with the green plants, and when the lights go on at night, it lights up the whole block. My problem is that the houses are too big. Okay? You're taking away the neighborhood charm of why we live here. I don't need a hotel across the street from my house. I don't. This may be a beautiful house, but that is a small piece of land. And I just think that the council, the planning and zoning, and all these kind of things, there's a reason why they don't want this house. It's huge. I'm looking at it. So I don't know what the answer is, but I think that there's a reason why this house is not being approved. I'm not part of all these meetings. I just came as a concerned owner of what's happening. There's this house down the street from me. It's up for sale. It's another square box, huge square box, 4.9 million. The owner moved into it because they can't sell it. There's another one on 97th Street, another huge box that's going to be 6.9 million. Who is coming to live here in these huge boxes? That is my concern. Where does it end?
The lighting that you're talking about is just...
All on the soffits. When he turned on the house, the whole house lights up the whole entire block. And I live across the street.
JC, Ron.
So I'm just telling you, there
The
must be
lighting.
lights every foot on his soffit that go around his entire house.
Which house are you talking about?
The one across the
The one
street.
next door?
His up,
The one next door to
this one.
That's still under construction.
Uh-huh.
Well,
Yeah. It's a beautiful house from the front because it's got angles and everything.
Right, but the
But
light-
what do I look at? A
That's-
white wall and lights everywhere. So, there's got to be some happy medium between what he wants and what the neighborhood calls for. Those bigger houses are on the water. They're not on my side. They're on the other side. So that's why I came. I just wanted to...
What was your address?
1360 99th Street.
Okay, thank you.
Thank you. What?
Okay.
You want me to sit down?
You may, if you
You have
like.
25 seconds, 20 seconds.
I just wanted to make sure that if we're going to have somebody go out there and check those lights,
Yeah.
to make
We have
sure,
lighting
we
requirements.
have lighting requirements to make sure that that's not, I mean, that's, okay.
Ken, that's it. He didn't-
Nope, okay, is there anybody else? No, okay.
Oh, wait, hold on, wait. Do we have one more coming
We
up?
have one more. Ms. Mizrahi, please come
Tony
forward.
Seidman, 10,000 West Broadview Drive.
Mr. Side, you're not speaking on this house, are you, or are you speaking
No.
on your own?
My
So,
own.
for your own house, you have to wait.
Okay, thank
So-
you.
Thank you. Next one.
Hi. Happens to be that I'm the neighbor on 7th Street. next to the big house that they're making.
Name and address.
Name and address, please, for the
My name is
record.
Elena Mistrahi. I live in 97th Street, 1330. So I didn't bring a picture of my house, but my house is one story, and they're building this huge house next to mine. When I bought my lot, there was a very small house. They knock it down and they make a huge project that I believe that I went to ask for the plans when they were when they came to the city to build it. And I don't think it matched what they're doing right now. But by any case, you could see, I took pictures of my property, how you look like it's really suffocating when you're on the side of my property. Maybe they are 10 feet, but it's so tall and it's so big that it's intimidating. It's very intimidating. You don't even have privacy because I don't know even if the lot is 10,000 if I'm 10,600, and I think it's too big for the lot. Is for the neighbors, I'm talking about me, they could be happy, but I'm not. And I even don't think that this staircase that I don't know, I could pass it.
Yeah, pass them all.
Please pass.
That they approved. It doesn't even bother me, but for sure bothers my neighbor on the back. How? Even the pipes that they're coming out from the ceiling, that they put, it splashed all over my property. And I don't know even if these big houses, the city requires them to do retaining walls, because for sure they're much higher than everyone else. And it does, like he mentioned before about the other house, it does bring problems to the houses next to it. So I approached the owner and I asked him about the retaining walls. He was not so sure about it. So I want to really leave on record if, we are going to push for that or not, because really when they do these massive houses and they have a huge deck, really I think 10 feet away from mine, for sure, and I'm having now problems coming water. So this is something that the city should, thank God they don't have a CO yet, so it's something that we could deal now before problem starts. So I'm just addressing that, just be careful.
You live next door to...
Yes, I took the picture from my backyard.
JC, can you look after and see what's going on as far as the drainage? Because that's the same problem we're having now.
So that's my... Even, I don't know if you see the emergency staircase that they put. I don't know if they even approve it. It looks... I don't know.
Well, we now have, I appreciate we now have the pictures on there, so let's follow up with our new procedure and make sure that this is actually being built to what was approved.
Even, I think for sure, the retaining walls are not done yet, and he already finished with the shell. Usually you do the retaining walls when you do the shell, because price-wise it's more convenience, so it's weird that they didn't do it yet. So just...
But thank you. We're going to keep these...
Thank you for
coming
Thank you so much for your time. Okay, no more.
That's it for public
That's
comment.
for Kelly.
Can we put aside this rumor about the pool? You said that was not one of the points that was a deal breaker for this. It was just a suggestion?
Well, let me just say it on a larger picture. It's our job as the office of the town attorney to make sure that whatever decision you arrive at, we can defend confidently in court. Your decision should be based on section 523-.1, not what happened before. And the reason we have this appellate process, and it's a de novo process, is for you all to use your judgment with the plans that are before you based upon the code as an independent body with an independent decision. And that's what our code requires. So regardless of what was proffered or otherwise.
All right, understood. Secondly, it was mentioned that there might be a notice issue. How is this notice to the neighbors?
This was
meeting?
noticed pursuant to the code.
How is that?
There is no 375 feet requirement with this one.
So this was just posted as usual and...
Correct.
And then it was mentioned earlier, that Mr. Miller approved it. We have a planning and zoning board, as you know, for a reason, like many cities do, to give some artistic suggestion in some cases. And I'm just wondering if this could not have been solved at that level to come back. You know, if we didn't take into consideration in the process, if the town, you know, didn't want the input of a planning and zoning board, they would simply just have Michael Miller, and that would be it. You'd come, you'd meet the code, and that would be it. And I think it is, you know, they're doing it in the best interest of the owners, but also of the entire town, because like it was mentioned, if things are being built that are not marketable, that's not good for the entire town. You know, things that sit empty. So on our planning and zoning board, we have architects, real estate professionals, you know, and that's what they're there for, to lend the suggestions.
Excuse me, but with all due respect to the prior speakers, the lighting issue has nothing to do with this property, nor does it have to do with the property next door that is under construction, because there's still no electricity out there. So that's not it. And the height requirements that the woman that spoke before was complaining that she's feeling dwarfed, but she's on an inside lot surrounded by smaller houses, but on one side she's got a bigger house. This is a corner lot, which takes up two sides of the property on an arc. So the area that it is encompassing is far greater. The house is much smaller than the lot could substantiate. We could have gone to a much bigger house to say to 50% of the land. Here we're only using 33 1/3% of the land. But as far as your comments, Ms. Reed, about the reason for the Planning and Zoning Board, that's arbitrary. They take a look at something and some architect may say, oh, I don't like big houses, or as was mentioned. Or someone says, well, I think we should have only mansard roofs.
You're not helping your argument with that, so
Yeah.
my advice to you is end that part.
Where we're coming from, but each house is designed on this island. We're not cookie cutters. We don't have the same things that we had in the 1950s, where there was five different styles and they were built all over the island. Now we have new conceptual architecture that's really very pleasing, as far as I'm concerned.
All right, Elizabeth,
Thank you.
and then we're going to call it.
Well, I'd like to make a comment when she's done.
I have a question. Can I make one small comment?
Mr. Pelosi.
Can I make one comment?
I'd like to hear whatever your comment is.
As far as this property concerned, our setback in the front is 25. We are in some areas almost 35 feet. So we are very far in, the same as on each side. We are not right on each on the property setback. We have plenty of space on that. Second, overall, our height is on the ceiling is 1 feet lower because we changed the elevation as far as the flood elevation. Next door is 14-foot ceiling. This one is 13-foot ceiling, so it's 1 feet less. I think for the second time, my company has designed a building that it stand out, and I guess the board members, they were not ready to see a design like that. They all want a box in the front, a little bit here and there, and they are used to that kind of look. With all respect, you know,
Just a couple of things. I think first of all, you know, please understand that, you know, our job is to deal with competing property rights,
Correct.
right? So it's you, sir, but it's also your neighbors and the town as a whole. And so we're in a tough, it's a tough situation, right, that we have. I do think it's important for us, and you were not part of these conversations, we were very spirited with the P&Z board about things that we wanted to see, and instructions that we gave them. And I think there's a certain point in this that we have to back them up because we pushed them so hard. I want to ask a question because we have to weigh this against the long-term cost to the town.
I'm sorry?
Yeah, question that I have for you is,
Yes.
after this, if it gets denied here, right, they have an additional appeal, correct?
They can go to the courts.
What is the
Go
likelihood?
back to P and Z?
No.
No, they can take this site plan approval, and they can go to the court, and they can ask the courts to see what we did, and whether it was correct or not.
But,
How-
no, but I guess, I'm sorry.
Go ahead, I think
What
you're
was
going to same
asking
place
is,
I am, so go ahead.
But they could say, okay, we don't want to go to circuit court, we're going to do some redesigning and make a new submission to P and Z.
It would be a
If they-
brand-new site.
Brand new
Right.
submission. I'm
Correct.
just saying that would be an alternative if they
Correct.
chose.
Yeah,
exactly.
their choices would be as follows. If you denied it, they could go to the circuit court, sitting in its appellate capacity. The town would make the argument that in situations of planning and zoning, our decisions are given great weight by the courts. That's the law. And they can make their arguments however they want. Or they can say, okay, perhaps we give more credence to the Planning and Zoning Board, and we redesign this, we go back, and we submit something else. Those are their choices.
Question for you. So let's say they appeal it and they go out. Will we be providing the court with the same information that we were provided here?
We can only provide the record that we have.
That's why I was sworn in.
So this would be,
Yes.
so basically the information that was provided here would be what would go there?
Correct, and what was submitted today as well.
Okay.
And they would also have the right to possibly try to submit the full video as well,
Yeah.
the record below.
Yeah.
Planning and zoning board meetings.
Correct. I have a few comments. I have to admit, I was taken back by, to have Mrs. Green and Mrs. Mizrahi come here and correctly point out about the large homes. It should be noted, we need to say this on the record, that many of us on the council have been very, I would say, concerned about the homes that have been approved by planning and zoning. And, this seems to be a reoccurring occurrence that I have personally with the issues of how planning and zoning goes about their business. They approved every single building that they're building now, they approved. So if you don't like the house that you're living next to, they're the ones that approved it. It never went to us, it's them. Because we've complained and complained and complained, we had a meeting where planning and zoning came and made some comments about possible changes. But that was only after months and months and months of us literally griping and our expectations that they come to us with ideas. Finally came to that, and we passed an ordinance changing the law. My understanding is that this house would not comply with the new ordinance. It does.
Yes.
Marlene, is that true?
Not on the second floor.
It would not on the second floor. And I understand that. But here's the problem. They came in with the old code. For planning and zoning to approve all those other buildings and all those other homes, and then at the last minute, since this past, 2 months ago, to deny these property owners' rights because they just don't like the mass structure is somewhat disingenuous. To be honest, if you only get so many bites at the apple. If you don't like it, that's one thing, but it meets the code. In fact, it exceeds the code when it comes to some of the setbacks. Even Michael Miller even approved it, which is, to be quite honest, hard to imagine from my standpoint. That's, honest to God, that's really rare. If they were coming to us currently, I wouldn't be in favor of it because obviously the code has changed. But they applied before the code was done. Everyone has to be presented equal before the law. That's kind of how I'm looking at it. They have a plan that meets and exceeds our code and our standards. I don't see anything wrong with the house other than the fact that is it big? Of course it's big. But you know what? That's why we changed the code. But to just deny them because we don't like it, that's singling out one property owner and doesn't take into account the fact that we need to treat everyone equally. And that's a big difference. And I think the council has done its job in changing the code, and there may be more changes. But to be honest, this is something that should have occurred years ago with planning and zoning, and of course, it didn't get done. And I don't think we should get blamed for, like I said, the inadequacies that was done previously.
Okay. I'm going to just say a couple things real quick. I'll be less than half that time. Jordan's. But here, look, I just want to say this. It's a very clear and obvious that this is all simply a debate about the size of the home.
Right.
It's not, the design. It's not about how many windows and breaking up. This structure obviously is not a mirror image of some of the concrete, just behemoths that we've seen in the past, where it's nothing more than a solid wall. This is somewhat different. I'm really torn on this one. I got to be honest, because the problem here is that the protection of the property owner's rights for this particular property to build what is allowed or was allowed under the code at that time is something important to me. Even I really did seem to bend over backwards to make sure the design was actually something that would appeal to, I guess, everybody with regard to breaking up the concrete. At the same time, the neighbors' rights have to be looked at as well. I don't know yet. We're going to vote in about a moment, and I'm still trying to decide. But I want to say, I just want to make sure everybody understands, this is not a debate about anything other than the size of the home. And let's be honest, that's all it is. And if there's a desire for us to change in the future the size of homes on lots, that's what should be looked at. Not because otherwise there's no way for anybody to actually fit with the parameters.
So before...
I have a question for the attorney. Can we make, how much discretion do we have regarding this project? I mean, can you read our task again?
Sure, I'd be happy to, because it is important and it's the only thing that guides you.
Well, because this is permanent. Sure. I agree a lot with what Jordan says, but this is a permanent thing that we're talking about here, and this is going to be here for a really long time.
Sure. Let me read the code. Section 5-23.1, architectural and aesthetic reviews of plans, failure to comply with plans as agreed. The Planning and Zoning Board shall examine, approve with conditions, or disapprove the issuance of a building permit in any matter subject to its jurisdiction after consideration of whether the following criteria are complied with. 1. The plan for the proposed structure or project is in conformity with the good taste, good design, and in general contributes to the image of the town as a place of beauty, spaciousness, harmony, taste, fitness, broad vistas, and high quality. 2. The proposed structure or project is not, in its exterior design and appearance, of inferior qualities, such as to cause the nature of the local environment or evolving environment to materially depreciate in appearance and value. 3. The proposed structure is in conformity with the standards of this code and other applicable ordinances insofar as the location and appearance of the buildings and structures are involved. 4. The proposed structure or project is in harmony with the other actual and proposed development in the general area, considering the following additional criteria. A. Site layout, orientation, location of structures in relationship to one another and to open spaces and topography. B. Harmonious relationship with existing and proposed adjoining developments, avoiding both excessive variety and monotonous repetition, but allowing similarity of style if warranted. C. Maximum height, area setbacks, and overall masks, as well as part of any structure, paren buildings, wall screens, towers, or signs, closed paren, and effective concealment of all mechanical equipment. D. Bold design, materials, and colors to be sympathetic with surroundings. E. Harmony of materials, colors, and composition of low sides of a structure, which are visible simultaneously. F. Consistency of composition and treatment. G. Location and type of planting with due regard for climatic conditions, preservation of specimen and landmark plantings upon a site, and proper irrigation to ensure maintenance of all plant materials. H. Design and appropriateness of signs as well as interior and exterior lighting. I. Graphics as understood in architectural designs. B. If all the above criteria are met, the application shall be approved. Conditions may be applied when the proposed building or structure does not comply with the above criteria and shall be such as to bring said structure or project into conformity. If any application is disapproved, and so on and so forth. So you could actually approve this with the conditions that you see fit as well.
Before we, before we vote, I just want to ask you, do you want to go back to P and Z? Because if whatever happens, you do understand. Okay, okay.
This is the design that we have approved, and this is the design that is ready to be built.
Okay, please.
I'll move it.
Second?
Awesome.
It fails. Thank you. Okay, let's go back.
Can I just make another comment? I mean, I know that, I mean, one of the issues here, and I understand what Ms. Green and Ms. Rodman said, and we've been having this debate with, or conversation with Planning and Zoning Board. No matter what they come back with, if they, you know, whether they appeal this or come back with a different design, you're still going to have a 8,000 square foot house here. It may be a little bit different in the second story setbacks under the new code if that applies, but you're still going to have what we refer to sometimes as these massive structures that are next door to one-story older homes. And unless we radically change the code, the building code in this town, all of these large structures do comply with the code, as was pointed out by the attorney. They meet the setbacks, they meet the height, they meet the landscaping requirements and so forth. So, we're going to continue to be in this circumstance where we have, I live in a 1957 home, 50s homes that are next door to much larger, two-story structures. So no matter what comes back, you're still going to face the same issues.
Okay.
Yeah, but one of the key things that Frank said was harmony and synergy with these,
I understand that, but I mean, I don't know how you harmonize a two-story, necessarily a two-story, 8,000 square foot structure
Property values.
with a, let's say, 2,500, 3,000 square foot, one-story home adjacent to it. I mean, the complaints are that we're looking up at, we have a smaller home, we're looking up at this very large structure because we're built at grade and they're built at, above base flood elevation, so there's even a higher height difference. It is what it is. I mean, I understand the property value and I understand that the gentleman owns a piece of property in this town and is entitled to build a house that he likes. I mean, I remember when we were planning and zoning, and I remember once voting against a house, and then afterwards I had second thoughts about it, like, who am I to say, because it's what they want.
Just to put reference here, and you and I were on the council when
we were
Dr. Whittles,
when
we were on planning and zoning, let's say, when Dr. Whittles presented his home. Dr. Whittles has a 22,000 square foot lot, and his home is 7,000 feet, and we were, oh my God, 7,000 feet in Bay Harbor.
But that was the market at the time. It's
and we thought it was huge. Now they put 7,000 square feet on a 10,000 square foot lot.
Right.
So I think this council really has to move on. Changing, I think we definitely have to change something. I'm not saying we have to change it radically like you're suggesting.
No, I'm not suggesting we do that. I'm just saying that's what would be
it's
required.
It's really, not fair what, these guys went through, but you know what? Once we approve something, it's permanent.
Right. But I will also say that with the discussions with Planning and Zoning Board, I mean, there was some discussion about requiring or not permitting houses this large. And that really had almost no support in Planning and Zoning because they didn't feel that the appropriate approach was to limit the size of houses, rather they were looking at, second story setbacks and, in articulation.
And that's the same set. And I think, so I think that's the next set of code that we really should consider changing.
Well, then we need to have a workshop on it.
Before we move on from this, I just want to make sure the record is very clear. The vote was to deny the appeal and to affirm the decision.
There was no second.
Well, you have to make a vote.
Seconding is...
Well, the effect of your vote and non-vote was such
that the appeal was denied.
Was that the appeal was denied and the Planning and Zoning's decision was affirmed. Okay? Just so that the record is very clear as to the actions of the council.
Yes, clear. Okay, so now we go
Okay,
back
now we go back,
to 3.
now we go back to 3. Is the attorney...
Which is number 1. The new number 1. Ours is the new one.
Excuse me, just one second, Mr. Seiden. Would you swear in, because I noticed the Seidens didn't actually swear in when you originally...
Okay. All those who are going to testify regarding the public hearing 3 and 4, raise your right hand. Do you swear to tell the whole truth, nothing but the truth, so help you God?
Yes.
Okay. Everyone is, Mayor, I just want to say, after the applicant is done, you'll take public comment, then the applicant will have, and the council comments, and then the applicant will have a rebuttal.
Okay.
I want to say thank you for all the empathy. Greatly appreciate it. I think that most of you were not here when I filed my house application, 2013. So I don't think you're aware. Your approach now is much more comprehensive. You do a much better job of making sure what gets planned gets built. You know, this conversation about my roof, there was 57 inspections on my house, passed every one, never failed an inspection. The roof was designed in court with your building department and approved at 3 different stages. So I am here at your mercy because my contractor happens to be very, you know...
You can leave that word out.
We'll take Barry as a description.
Let the record leave that line blank.
So I think that, you know, it was very heated when I received that vacate order. He was very rude, my contractor, that day, and about an hour later, I was served with this vacate order. And we went through a lot of legal exercise. Mr. Watson's aware of it, Mr. Simone's aware of it, and I'm here in the middle. So I'm just looking for your consideration to my plight. I'm not looking to set any precedents or make any new law. That's all I have to say. Thank you.
Thank you.
Thank you.
Thank you, sir.
Frank, can I ask a question before council? I understand under the code that the master has the authority to mitigate up to 50% of any fines.
That's correct.
Does the council have the ability to overturn that mitigation, or does he, if we don't think it's appropriate, or is his action final in terms of that 50%?
It's further appealable to the town council.
So if we do not, so if we're not in agreement with this mitigation, the town council, how does that get back to the council? By whom is appealing that then?
Sure. The process goes, the special master can only mitigate it down to 50% of whatever the fine is that he or she were to choose. And then it could be appealed to the town council, who has ultimate discretion.
For further
mitigation.
Right, but the point is, if the council doesn't feel that the 50% mitigation was appropriate under the circumstances, can we reverse the special master's mitigation?
You could, yes. There hasn't been an instance yet where I would file an appeal to you on behalf of the town, but we've certainly thought of it, and it could possibly occur. Yes.
So it would be...
Where we would think that...
Right, but I'm saying, who initiates that appeal on behalf of the town? The town manager, the town clerk, the building official? How do we get that back to us?
It would most likely be the town manager, or in that instance, or it would probably be the head of planning and zoning.
Okay.
I mean, not planning and zoning, I'm sorry, code enforcement. Sorry.
So, because we were talking earlier...
Correct.
Before the applicant went out about having a condition of the variance that they would waive their rights with respect to mitigation, or in contesting the current code enforcement process, I'm just saying that may be an alternative, knowing that it could come back to us.
Let's see their response to that first.
No, I understand. I just wanted to educate myself and others.
I just want to say that I was just suggesting procedurally the council could make, because it has the authority, as a condition of granting a variance, some agreement, some consensus, some settlement and resolution of the outstanding fine issues to resolve that, that present litigation. It can be all, nothing, something, whatever, and I don't know if the applicant would agree or not. That's what counsel, when we took our break.
Can I ask one question? Could we also stipulate, because the tolls have been, the fines have been tolling for some time, could you also pick a specific date, like, for example, instead of picking today, could you, hypothetically, they applied for a variance a while ago and they've been waiting, could you put it from the date that they applied for the variance? Could you do that hypothetically also?
Yes, you could.
Okay. So we have pretty much free reign.
I want to hear the applicant's response to
Right.
their conversation.
In reference to the fine, now, again, I'm trying to say I'm innocent, but of course, you say you're innocent. But I come home, I find out that my contractor insulted Evelyn or something like that, was very rude, and I wind up with this eviction notice for $200 a day on my house. Not calling it an unsafe structure. Now, I said I passed 57 inspections. I don't want to go into the quality of the inspections, but I passed and I made sure that everything is safe. I have a little knowledge of that. Unfortunately, during the building of my house, I was hospitalized twice, and I couldn't oversee as well as I wish I did. So, I just want to be fair despite, about what's happening here. The fine is punitive, and I never did it, yes, my eaves on the roof are 6 inches or a foot too big on the right or the left, but maybe my pool deck is 6 inches too high. I didn't know inches were really what defines everything we're about. So I wish you the best. I hope we can come to a favorable decision. Thank you.
Thank you. So again, Ethan Wassman for the record. Thank you for your indulgence in allowing us to step out, and we appreciate the other applicant allowing us to go first tonight. I do want to start by saying we appreciate staff and the administration's support of this application, as well as the neighborhood support, quite frankly, for these variances. After discussing with my client, tonight to contract for these variances at a significant cost is just not something we're prepared to do right now. There's a lot of analysis that will have to go into this on several factors. Obviously, a straight economic analysis, the number's already in the 6 figures, so we have to study that. But also on the rights we are waiving, to agree that we are an unsafe structure tonight. I mean, I know Frank, the city attorney, has worked with our office on this. We're not prepared to waive our rights that we are an unsafe structure. We are talking about the walkways on the side of our home. We're not discussing the safety, the habitability of the home tonight. And so I apologize. I know you all have made efforts to get us there on the variances subject to the economic factors, but we really have to preserve our rights. If it takes a continuance so that we can work with staff to address this issue, or if we can get an approval tonight and that we work with the administration to negotiate this, we're happy to do that. But we can't just waive our rights tonight and agree to the full fine.
Frank, can they withdraw and then reschedule?
Yes.
But they have to
If they
withdraw,
want to.
or can it be adjourned? I don't know.
Oh, straight continuance.
But let me ask you, what are we hoping to achieve by this? I mean, I'm not really sure what the, I'm not sure what the delay
Are you planning on negotiating with the town?
They can't until this is resolved, that's the
Well,
problem.
I think that's part of what they want to
I think
do.
we need clarification, because my understanding was the same as yours,
Yeah,
Josh,
they
that-
can't, it runs and it can't be done until, they have to actually have a resolution here before we figure out because otherwise the fine's going to continue and everything else.
Jurisdictionally, it's before the special master.
Right, exactly. So, I mean,
It's not here.
sending it
That
back there
item-
doesn't make sense.
That component of this case is not here
Well,
tonight.
Exactly, and that's the problem.
Except that Craig said that we can wrap it around.
We can't, but that's why I'm saying I don't want to push it off. I'm saying we have to-
They're saying that they don't want to wrap it around.
You could if there's agreement, and if they want to continue this to the November, you could certainly do that as well.
Can we stop the fines from tolling until then?
No.
No.
However, they could always come to some resolution where they would say, yes, we may not think 6 figures is the appropriate remedy, however, there's something else that we could study and talk about as well.
Give us time to analyze the issue. This is a significant cost you're asking us to agree to tonight, and to be perfectly blunt, we have to analyze it, we have to study it. Aside from the economic factors, there's the legal factors as well of agreeing that we are an unsafe structure, which we cannot be, we're not prepared to do.
And I got to ask you one other quick thing, because it goes back to...
Agreeing that you're an unsafe structure, Craig, are they agreeing that they're an unsafe structure?
Well, there are 2 things here. One is that there's no CO. We
Right.
disagree on that. I
Which
think
is
we
the largest
agree on
issue.
almost everything. We disagree on that. And secondly, occupying a house without final approvals, which in our opinion there is no final approval for this, that is really what the fine is tolling on.
And let me just
We're
say,
not saying that
sorry.
it's about to fall into the ocean. It's more of a legal distinction than a actual.
So I think with time, we could, if we come back next month, we could
So
flush out some of those
you want
underlying
that time
issues.
to be able to work with the town on coming to a resolution?
Yes, the applicant can do that. The applicant can ask for a deferral and a withdrawal from any further hearing at this meeting. And yes, the fines continue, but it's all subject to resolution as part of a settlement or otherwise. The council has that authority. So in the final analysis, if staff can come to some decision regarding the fines, or if that were to be a condition of a variance granting, we haven't agreed on that yet. It just was a suggestion, but we certainly have time to talk if council's willing to defer any further action until next meeting, or withdraw the application for variance to refile it, either one.
And not to beat a dead horse, but I'm going to say it regardless. If it is going to come back, please, I'd like to have a determination as far as the flood problem for the next door neighbors prior to that time period. Okay?
That's easily could be done, but
That can be done.
honestly,
I
this,
just want it done before we...
just so we're clear,
That's the only-
there's the zoning issue of the variances. Nobody's here is questioning the sturdiness of the house.
No,
As they said,
I
but-
understand. There's a lot of little things, but I mean, look, I'd rather vote tonight, quite honestly. I'd rather vote tonight, and I'd rather we actually come to a resolution tonight. But I will mention one thing. Like I was just saying, because you turned your head, I'd rather take care of this tonight, but I do want everybody to be aware that, one of the affidavits, or not affidavit, but the statement here for the neighbor, which is Mr. Mamain, this is for the spec house. So it's kind of somewhat, right, no, I understand, I'm just saying, but that house across the street is going to be for sale for somebody else. But again, I'd rather take care of this tonight if everybody's...
But we do have a letter from the adjacent neighbor,
Right,
and
a
then
call
we
from
have
the
a
other.
verbal call,
I
so
just want
all
it on the
three.
record that across the street
Right.
is not going to be a neighbor.
Is there any of these that we can at least deal with that we're in agreement? I mean, we discussed the ones as far as the landscaping. I mean,
But they're all wrapped around...
no, they're all individually. We can vote on them
We
individually.
have to, let's first...
Can I just clarify something? So our legal team has determined that it is possible, after the fact, if we were to vote in favor of this variance tonight, and then it would go to the special master, if we weren't happy with that resolution, we could...
Overrule it.
Thank
You could.
Yeah, exactly. That's why...
So I'm ready to vote tonight.
I am as well.
Is our overrule final, or it goes back out to the court?
No. Well, they can appeal.
If we overrule the
They can-
special master
yeah, they
with
can make
respect
an
to
appeal.
mitigation.
Yeah, but they can appeal it to the courts.
Right, they can appeal to the court.
So we're in the same boat. It's
No,
back
but
and forth.
at that point, I mean, we've got a better argument at that point. I'd rather take care of this tonight. That's my first thought.
So would I.
We haven't done it yet.
So, me too.
Okay, I think we're going to...
I think we're ready to vote.
What's the motion?
Motion to approve.
I'm going to...
All 6, or,
Well-
I'm just asking.
Well,
There's 6 variance requests.
Yeah, there's a subject to. I want,
Why-
again, subject to, and I think it'll be fine. I just don't want the neighbors coming back later on, and as long as that's okay, no problem.
yeah, what Josh says. All 6, but what Josh said in regards to the...
Building
the
inspector
flood-
saying
Yeah,
there's
of
no
course.
flood issue.
That includes a condition, the retrofit upon sale?
Of the walkway.
With just the walkway?
Yes, that the walkway, that upon the Sidons, not being the owners of the property, that it would revert back to the current code. And also that, obviously, we would be able to have a bite at the apple in regards to the potential fines after it goes through the special master process.
Yes.
That's it.
I'd like it to come to us.
Second.
Will the...
Final
will the
approval.
the variance leading into the CO be contingent upon resolution of all fines that are outstanding?
No, that's not
No.
part of this motion.
No, it's the opposite. Once it goes through the process, if we don't like it, we'll have the ability to bring it back and change it to our liking. So to be honest, they potentially can get their variances, but yet it's still looming over them as far as what occurs with the special master is not the final decision. It will eventually come back to us if we don't agree.
You're retaining jurisdiction over the fines.
Let me articulate it this way. I would recommend that the variance or variances as a council deems fit be approved subject to and with conditions, including, one, the covenants running with the land for the walkways, until and unless the Mr. Sidon is not the owner anymore or passes away, and the deck.
No. Until they're not the owners anymore. That's right.
Until they're not the owners.
Not the passing away portion. I don't want that.
Well, either way, whatever the council wants, and subject to a satisfactory resolution of the special master proceedings. And that leaves it open to an agreement by the council to modify or whatever. Otherwise, if you grant the variances without that condition, the most you can do is put a lien on the
And
property.
subject to the building inspector signing off on.
Yeah, right.
That's my motion. There you go. Perfect. Couldn't say it better myself.
Okay. That's why we have a town attorney.
Exactly. All right.
Okay.
Is there a second?
Now we need a vote.
Who seconded it?
Okay.
Okay. Oh, so there
Josh
we go.
did.
Very good.
Okay. You ready to vote?
We're ready to
Yep.
vote.
I think so.
Councilmember Yaffe.
4.
Councilmember Tricoche.
4.
Councilmember Salver.
4.
Councilmember Reed. 4. Councilmember Leonard.
4.
Vice Mayor Fuller.
4.
Mayor Bruder.
4.
It's unanimous.
Thank you.
Thank you, sir.
Thank you all very much. Have a great night.
We take part? Yes, let's take a time now.
All right.